Hello, I'm J. Jermaine Bay of Melonia Morris Prairie, Monte, Colorado. The acronym is AMPAC. I'm the Chief Judge of Consular Court. Today is Class 114. Class 114. What did we learn in Class 113? Well, we're starting to learn a lot more about laws, right? International law. We've been reading over some of the United Nations resolutions, and we're learning about law, international law. But we're also learning about Moroccan laws, right? How Moors need to enact bills and turn those bills into legislation, right? But we've also been learning about Moorish Americans and the lack thereof, that Moorish Americans are not only stateless, but that Moorish Americans are also lawless, right? What do I mean by the fact that Moorish Americans are lawless? Well, let me give you an example. Okay, let's take a look at Dred Scott. Dred Scott was lawless. He was stateless, and Dred Scott was lawless, right? Dred Scott tried to utilize the Missouri Compromise, right, which is local state statutes, for his defense. Then he tried to take it to a federal level, and it went all the way to the Supreme Court, and Justice Taney turned around and told Dred Scott, "You're a plaintiff in error." Well, why did he tell him he was plaintiff in error? It's because Dred Scott was not a citizen. He could not utilize the Supreme Court as his defense, which tells you that Dred Scott did not have a legal argument. He didn't have a legal defense because he could not use the procedures of the courts. Why is it that he couldn't use the procedures of the courts? It's because he was not a citizen. Only citizens could use the courts of the United States of America and of the several states. And Dred Scott was not a citizen. So therefore, he was stateless and lawless, right? But keep in mind, Justice Taney knew that Dred Scott was what? A Moor. He knew that. He knew that Dred Scott was a Moorish subject, and according to the bilateral treaty of peace and friendship of 1887 and 1836. Keeping in mind, the case of Dred Scott took place in 1856, right? Just 20 years after the United States of America had renewed the bilateral treaty of peace and friendship. And Justice Taney, sitting in the Supreme Court, he knew about the Treaty of Peace and Friendship. He knew Dred Scott had to go back to Morocco in order to invoke the laws of Morocco, the Empire of Morocco. They wasn't about to tell Dred Scott that he was a Moor. There's no fun in that, right? Because the United States was in the process of trying to naturalize all of the Moors, right? You have to understand the time frame of what was going on in 1856. Moors have to go back and look up what's called the Morocco-British Treaty of the year 1856. And you see that Great Britain signed a bilateral treaty with the Sultan of Morocco that allowed Great Britain to naturalize Moors who were in Great Britain. Okay, so in this case, 1856, Justice Taney understood the timing and the tempo of what was going on from a political perspective. From a political perspective, right? So Justice Taney is taking a look at that case. He says, "No, Dred Scott, you ain't got nothing coming. You're a Moor subject. You're not a citizen of the United States of America." And this is the same problem that Moorish Americans are having today. Moorish Americans are Dred Scott all over again because Dred Scott was stateless, right? And which made him lawless because he had no laws he could depend on because he didn't realize that he was what? Moroccan. Dred Scott was not actually Dred Scott. Dred Scott's name should have been what? Dred Bay or Dred Ill or Dred Ali or Dred Day or Dred Owl, right? That should have been his name. But his last name was Scott. He was property. Okay? Moorish Americans are in the same status. Moorish Americans say, "I don't come under the jurisdiction of the United States of America or their several union states. I don't come under their laws." What Moorish Americans are saying out loud is that they're stateless because they haven't pledged their allegiance back to a Moroccan state, and they're saying that they're lawless because there's no laws that help to defend Moorish Americans. Moorish Americans cannot put together a legal argument or a legal defense because they cannot go back and utilize any Moroccan laws to their advantage. And neither could Dred Scott. So Moorish Americans say they're not citizens of the United States of America while simultaneously trying to use the Missouri Compromise to their advantage. And guess what happens when they go to court? They end up being plaintiff in error or defendant in error because they're trying to fight it as if they're Moorish Americans. They're trying to fight it as if they're Dred Scott. And there are no laws for Moorish Americans. There's no statutes that represent a Moorish American state. There's no three branches of government for Moorish Americans. I say this with love. I say this with respect. This is an educational platform. So the Moorish Americans are Dred Scott all over again. They're lawless and stateless. But let's try to fast forward now. Okay, so Dred Scott loses in 1857. Now we fast forward, and what happens in 1865? Now you got the 13th Amendment that comes out that all of a sudden recognizes Moors as citizens. Next, you got the 14th Amendment that gives extra protections to Moors because now they've been naturalized as citizens of the United States of America. Then you have the 1870 Naturalization Act, right? And the 15th Amendment came out in the same year, 1870 Naturalization Act. 1870 is when the 15th Amendment came out. Now all of a sudden, Dred Scott got some laws he can use. But what type of laws? He can use American laws. He's a citizen now. But what type of citizen? Second class citizen. You see, Morris, you have to know the history. In 1856, Great Britain signed a treaty with the Sultan of Morocco that allowed Great Britain to put the Moors under naturalization status. They became citizens of Great Britain. Then in 1861, the Sultan signed a treaty with Spain to allow Spain to put the Moors under naturalization status, making them citizens of Spain. The Sultan signed all kinds of bilateral treaties with Germany, etc. So therefore, in 1861, going back to the United States of America, if Spain signed a bilateral treaty with the Sultan that allowed Spain to allow the Moors to be naturalized citizens, now so you look at the United States, and also they had World War I, which is commonly called the Civil War. So now they have a civil war because the North wanted to make the Moors citizens and give them citizen rights. The South said, no, keep these Moors as Moor subjects. That's what the Constitution says. That's what the treaty says. The South was saying, we're breaching the treaty. We're breaching the Constitution because the Constitution recognizes these Moors as subjects. The treaty recognizes these Moors as subjects. The treaty nor the Constitution of the United States recognized the Moors as citizens. It didn't recognize it. But the North wanted to turn around and make the Moors citizens because they saw that Great Britain had permission to do it, and they saw that Spain had permission to do it, and Germany, etc. So under what's called the Most Favored Nation Clause of the Treaty of Peace and Friendship, Article 24, the United States of America and Lincoln made the Moors citizens. Now let's fast forward. Now the Moors call themselves Moorish Americans, which is a corruption of our true status in the first place because we're actually Moroccans who've been adopted as Americans through the 13th, 14th, and 15th Amendment. It naturalized us, put us under the protections of the United States of America's laws as Americans, naturalized Americans. So now you look at the Moorish Americans, the Moorish Americans tell you, I'm Moorish American. They say, what's your nationality? Moorish American. Well, wait, time out. Moorish means Moroccan, and American means American. So you've taken this hybrid status of Moroccan American, and there's no such thing. It's a third-party interloper. The word Moorish American is a connotative linguistic. What's the denotative linguistic? It's Moroccan. What's the connotative linguistic? Moorish American. Okay, Moors have been taught, we got to come back to our own vine and fig tree, right? Okay, let's talk trees. Family tree. But let's look at it from a perspective of fruit. Let's say the Moors represent a cherry tree, and America represents an apple tree. What the Moorish Americans have done, if the Moroccan represents the cherry tree and the Americans represent an apple tree, what the Moors have done, they've grafted these two trees together to come up with a hybrid. They say this tree is actually producing cherries and apples. There's no fruit tree that produces two or more fruits at the same time. This is what the Moorish Americans have done. They've created a third-party interloper. It's a Frankenstein. It's not recognized nowhere in international law, in no treaty, no legislative act, nowhere on planet Earth. That means you're stateless and lawless because there's no state called Moorish America and there's no laws that represent Moorish America. So therefore, Moorish Americans keep saying their rights are being violated, and that's not true. The treaty says of 1880, Treaty of Madrid says what? You have to choose between the entire submission to the laws of the empire, which means you got to choose between two jurisdictions. It's Moroccan jurisdiction and American jurisdiction. You have to choose between these two. But what happened is, Dred Scott became an American. He was Moroccan. Then he got adopted under the 13th, 14th, and 15th Amendment. And then the Treaty of Madrid of 1880 allowed the United States as a multilateral treaty, several Christian countries, right? The Christian powers, the European powers, signed a multilateral treaty called the Madrid Convention of 1880. Article 15, paragraph 2 allowed all the Christian powers to put the Moors under naturalization status and put the Moors underneath their laws. So now all of a sudden the Moors say, okay, I'm Moorish American, but they don't realize Moorish means Moroccan. Instead of them choosing Moroccan or choosing American, they put the two together. That's a corruption of two different jurisdictions. That's what you call a fraudulent status. I say this with love. I say this with respect because I know the Moors are sensitive. So we'll talk about that some more today because Moors keep running around saying they're being kidnapped. Moors keep running around saying they're in hostages. We'll learn more about that today. I have to keep impressing upon the Moors that they're not Moorish Americans. I have no choice but to do this. As we keep studying international law keeps giving Moors answers to the test. International law keeps saying the states parties to the convention. That's how it opens up. It gives you a title about what the law is about. Then it tells you who can be a party to the law. It says the states parties to the convention. So states can only be parties to treaties. Okay, do Moorish Americans have a state? No. Automatically it means now they're not what? Parties to a convention. They're not parties to any treaty because they're stateless. Why are they stateless? Because they're claiming a name that does not exist anywhere in international law. And this is what Moors have to understand. So I'm going to keep talking about this because I'm trying to help the Moors understand what's called a legal argument. Right? What's your legal defense? Well, the first thing is the parties must be known. What party do you represent in the contract? Please point out in the contract your party name. Go to the Treaty of Peace and Friendship and point out your party name. You know what the Treaty of Peace and Friendship recognizes you as being? Moroccans. When you read all the treaties, you'll recognize it refers to us Moroccans. When you know the history, it refers to us Moroccans. It always have and always will. But you never see the words Moorish American. We'll talk about that some more today, all right? So let's go ahead and get into class. Okay, you know, I open up the Constitution. The Constitution's paramount. It's what recognizes you as a Moor. How else are you going to get recognized if, in fact, a constitution does not recognize you? You must have a constitution that recognizes the people. It recognizes the landmass you're claiming. It recognizes your government. And it recognizes, gives you an opportunity to get in relations with what? Other states. That's what constitutions do. And after that, the Constitution serves as a portal to get access to international law. That's what Moors have to understand. It's an access point. It's a key. It's a key to get access to what? Freedom. Your freedom can be found in international law. Once you understand international law, now you understand you need your own internal Moroccan laws for your state. We'll talk about that some more today. All right, let's go ahead and jump on in. Some more know this AMPAC's contact information. For those who are still looking for the AMPAC study sessions, you can find study sessions on these two different YouTube channels. Okay, take a screenshot of that. Okay, here's the contact information for the WRC. All right, take a screenshot of that. In addition to that, I want to share this with the Moors. This is AMPAC's contact information, okay? For those Moors who are interested in learning more about statehood, you can go to AMPAC Media and learn more about that. Okay, so up here it says learn more about statehood at YouTube AMPAC Media, and you can go to AMPAC, right? There's a Lothian Morris Pradium, Antioch, Georgia. They have a Sunday night class, okay? If you want to go on there and participate, here's their link, right? This is for their Telegram, so you can go ahead and take a screenshot of that, okay? All right, so I just want to say, also, I want to say thank you to good brother Abdul Smith Bey. He's the teacher for AMPAC Media. He's doing an excellent job. For those Moors out there who are listening to AMPAC Media, just understand that good brother Abdul has earned his right to talk about international law. He does an excellent job. For all his students on there, I congratulate his students for chiming in and having an opportunity to participate fully with good brother Abdul, right? Keeping in mind that brother Abdul is a wazir. He's the head of state for Lothian Morris Pradium, Antioch, Georgia, as well as he's the chairman of the WRC, which is the Wazir Regional Council. So he's holding those two offices. He's doing a great job. In addition to that, he's teaching, right? So he's participating fully in trying to uplift fallen humanity. And I just want to say thank you, good brother, for all that you do. And I want to let everybody know, good brother Abdul Smith Bey shall be respected. That must be understood, all right? Not only because he's the head of state, he automatically gets privileges and immunities, but at the same time, he should be respected because he's sharing information that's going to help all of us get freedom at the end of the day, all right? We're all in this together, okay? Let's continue. Okay, so as the Moors know, we're still going over the Charter of the United Nations of 1945, Chapter 7, which is about action with respect to threats to the peace, breaches of the peace, and acts of aggression, right? We've already read over Articles 39 through 51. Understanding right now that what we're studying as Moors is how do we deal with threats, breaches, and aggression? How do we deal with that? What's called laws, right? Let's take it to the board. Okay, so right now we're going over the Charter of the United Nations, Chapter 7, Articles 31 through 59. I should have put 39 through 51. Sorry about that. 39 through 51. Okay, Moors? All right, let's correct that. 39 through 51. Action with respect to threats to the peace, breaches of the peace, and acts of aggression, right? So when we're dealing with this as Moors, because Moors have been dealing with this for decades, would you agree with that? Okay, so what was the answer the whole time? Okay, here's the question and answer. What do Moors need in order to prevent and punish those who violate our human rights? Well, what do we need? What's the answer? We need statutes, legislation, and laws, right? Understanding that statute, legislation, law is the same words, right? They mean the same, okay? So what do we need? We got a drop-down box. We needed what? Moroccan state laws. So if we had Moroccan state laws, then we would have been able to protect ourselves and punish those who violated our rights. What type of rights? State rights. Because you got to understand, anything a colonist does to us, first person they're violating is who? The state. The state is a person in international law. Then they're violating the national of the state. But the first injury is actually to the state because the state is responsible for protecting its nationals. And the nationals turn around and protect the state. That's how it works, the duality, right? So in order for Moors to get their rights, human rights, your human rights is protected by the state, and the state extends sovereignty to you. That way you can protect the state. So all the Moors are sovereign underneath the state umbrella, all right? So therefore, if Moors don't have Moroccan state laws, that means that Moors are what? Lawless. And the reason why they're lawless is because they're what? Stateless. You see how easy that is? So we have to put things in sequential order. First is the state, right? First is the state. Then is what? The laws. There's no laws without a state. We need state laws, Morris. Once we have state laws, guess what we can do next? Now we can start to prosecute those who violate our rights. We can prosecute those who violate our statutes. We can prosecute those who violate our legislation. We can prosecute those who violate our laws. And guess what? We were never able to do that. This is why the Moorish Americans kept teaching everybody to try to do default judgments. The Moors didn't want to do nothing but get everything dismissed. That's all we ever did. Default judgment. Default judgment. Oh, you lack jurisdiction, so it's default judgment. But we wasn't using the Moroccan laws to hold them accountable. Where's your counterclaim, Moors? Let me say it again. How is you going to bring a counterclaim? You got to dismiss. Okay, what's your counterclaim? Because, anytime you're a defendant, you have a right for a counterclaim. What's your counterclaim? Moorish Americans don't have no counterclaim. Because what laws was you going to use to say that the Americans breached your Moroccan laws where it didn't exist? What did you use to try to get the case dismissed? You're using American laws. We'll talk about that today. But what is the answer to the test, Morris, that we were in the absence of? We were in the absence of Moroccan state laws. That's how we're going to solve this problem. Everything up here is about decolonization. What's the opposite of colonization? Decolonization.
Naturalization.
Yeah. So you go from what? Being naturalized to what? Nationalized. Naturalized, right? That's colonialism, to nationalize, right? But who can nationalize you? Only a state. Contrary to belief, Moors cannot get your sovereignty. You can't get nationality through a temple, and you sure as heck can't get it through RVA publications. There's no such thing. Only a state can extend nationality to you. That's the truth. We'll talk about that today, all right? Okay. All right, so in class 113, where we're going over the United Nations website that talks about the Office of Counterterrorism, because when you're dealing with terrorist acts, that means some foreign state is doing something to your nationals or doing something to your state, right? So that's what we're learning about, okay? We'll go ahead and scroll on down. We've gone through this before. We were still going over the 1979 instrument called regarding the taking of hostages. We had started going over that briefly. About the 1979 International Convention against the taking of hostages. Moors keep running around saying that they've been kidnapped, and Moors keep saying they're hostages, which is furthest from the truth. The question is, what type of Moor is a hostage? Where if you're Moorish American, then you're not a hostage, you haven't been kidnapped. If your Moroccan national is recognized by a Moroccan state, then yeah, there's a strong possibility that you've been kidnapped or been held hostage by a foreign power. We'll talk about that some more today, okay? All right. Okay, so when we click on it, it opens up the document, okay? We'll go ahead and start from the top. Now, more than likely, we probably won't finish reading it today because some other things I want to show the Moors, right? But we'll start reading it, and then I'll get into my correlations of what Moors need to understand, all right? Because we won't have to have a deep conversation today, a deeper conversation. Okay, what's the name of the title?
Multilateral International Convention Against the Taking of Hostages, adopted by the General Assembly of the United Nations on the 17th of December of 1979.
Okay, so this document has been out since 1979 about the taking of hostages, i.e. the kidnapping, right? Have the Moorish Americans been reading this? Well, the answer is no, right? We've been yelling this out loud, but yet we didn't go back and look at the legal argument and the legal defense we could have used if, in fact, the United States of America was breaching our right and making us hostages, right? We should have been reading this, Okay? All right, let's go ahead and start with the preamble again.
The states parties to this convention, having in mind the purpose and principles of the Charter of the United Nations concerning the maintenance of international peace and security and the promotion of friendly relations and cooperation among states, recognizing in particular that everyone has the right to life, liberty, and security of person, as set out in the Universal Declaration of Human Rights and the International Covenant on Civil and Political Rights, reaffirming the principle of equal rights and self-determination of peoples, as enshrined in the Charter of the United Nations and the Declaration of Principles of International Law concerning friendly relations and cooperation among states in accordance with the Charter of the United Nations, as well as in other relevant resolutions of the General Assembly. Considering that the taking of hostages is an offense of grave concern to the international community, and that, in accordance with the provisions of this convention, any person committing an act of hostage taking shall either be prosecuted or extradited. Being convinced that it is urgently necessary to develop international cooperation between states in devising and adopting effective measures for the prevention, prosecution, and punishment of all acts of taking of hostages as manifestations of international terrorism.
All right, so that's the preamble, okay? And let's go ahead and start reading over Article 1.
Have agreed to follows. Article 1. 1. Any person who seizes or detains or threatens to kill, to injure, or to continue to detain another person, hereinafter referred to as the hostage, in order to compel a third party, namely a state, an international intergovernmental organization, a natural or juridical person, or a group of persons, to do or abstain from doing any act as an explicit or implicit condition for the release of the hostage commits the offense of taking of hostages, hostage taking, within the meaning of this convention. 2. Any person who, A, attempts to commit an act of hostage taking, or B, participates as an accomplice of anyone who commits or attempts to commit an act of hostage taking, likewise commits an offense for the purpose of this convention. Article 2. Each state party shall make the offenses set forth in Article 1 punishable by appropriate penalties which take into account the grave nature of these offenses. Article 3. 1. The state party in the territory of which the hostage is held by the offender shall take all measures it considers appropriate to ease the situation of the hostage, in particular to secure his release and, after his release, to facilitate, when relevant, his departure. 2. If any object which the offender has obtained as a result of the taking of hostages comes into the custody of a state party, that state party shall return it as soon as possible to the hostage or the third party referred to in Article 1, as the case may be, or to the appropriate authorities thereof. Article 4. States parties shall cooperate in the prevention of the offenses set forth in Article 1, particularly by A, taking all practicable measures to prevent preparations in their respective territories for the commission of those offenses within or outside their territories, including measures to prohibit in their territories illegal activities of persons, groups, and organizations that encourage, instigate, organize, or engage in the preparation of acts of taking of hostages. B. Exchanging information and coordinating the taking of administrative and other measures as appropriate to prevent the commission of those offenses.
Pause. Okay, so Article 4. States parties shall cooperate in the prevention of the offenses set forth in Article 1, particularly by A, taking all practicable measures to prevent preparations in their respective territories for the commission of those offenses within or outside their territories, including measures to prohibit in their territories illegal activities of persons, groups, and other organizations that encourage, instigate, organize, or engage in the preparation of acts taking of hostages. What should the Moors take away from that? You see, Moors, we needed these type of laws. Not only can we stand on the well-settled principles of this 1979 treaty, but what we need to do, we needed to copy-paste this language and put it into what? A bill, and that bill would turn into a statute, legislation, or law, because as a bill is passed from our legislative branch over to the executive branch signs it into law. Now it becomes statute, legislation, and law. It becomes Moroccan law of the state, right? So we needed to take similar language of, let's say we take this whole document. We copy paste it into a Word doc, but that Word doc is titled as what? A bill for the state, right? It has the same similar language. We go in and we copy paste, plug and play to make it more about the parties that we're dealing with, such as United States of America, United States, and the several Union states. Right? But this is the language we needed in order to tell the United States of America, okay, here's how it's going to be in the jurisdiction of Morocco. If you guys do anything to violate our legislation, right? That's what all this is, legislation. Now we're going to be able to do what? Prosecute you. But we were always in the absence of laws. This is law we're reading. This is your legal defense. This is your legal argument. But you can only argue these points through what? A state. It keeps mentioning the word state over and over and over again. It says what? Article 4. States, parties. But the Moors are stateless. If you're stateless, that means you're lawless. But once you return to Morocco through a Moroccan state and pledge your allegiance to said state, now that state will have what? Laws to protect you. But more importantly, it was the obligation of the Moors, that's why I'm pointing this out, it was our obligation to take what? The Moors supposed to do this, taking all practical measures to prevent preparations in their respective territory. With the territory, your state. For the commission of those offenses within or outside their state, including measures to prohibit in their state illegal activities of persons, groups, and organizations that encourage, instigate, organize, or engage in the preparation of acts of taking of hostages. So the Moors needed what? Let's go back up. That's Article 4, right? We'll come back to it. What did Moors need? We needed Moroccan law not only to become a state party to this international law, right? Because we're going to flank the United States, right? We're going to become parties to this, right? Flanking with international law. But then we need to copy paste and have a bill that has this title, right? International Convention Against the Taking of Hostages, or you say Convention Against the Taking of Hostages Act, or something like that. You name it whatever you want, but now the title tells you you're putting together Moroccan law that prevents the United States of America, right, or any of their international organizations or their charters or their municipalities from doing anything to hold you as a hostage. But we needed laws that talked about that, right? So you create a bill, and now you convert it into law through your constitutional procedure, okay? That's what we needed more. That way we now tell them this is how it's going to be within our territory, right? This is how it's going to be within our what? State, okay? So now you go to section B. Exchanging information and coordinating the taking of administrative and other measures as appropriate to prevent the commission of those offenses. What does administrative mean? That's the administrative branch, right? That's your legislative branch, and your executive branch, that's the administration, right? This is how you enact laws, and the administration now enforces said laws, because administration oversees who? The law enforcement. If the law enforcement can't get something to cease and desist, then it goes over to the third branch. What's the third branch of government? Judicial branch.
Yeah.
Now you're dealing with what? Prosecution. That's why they keep talking about prosecution. You see? That's what Moors were in the absence of. We did not understand the three branches of government. We didn't understand the functions of it. We didn't understand the powers of it. That's what Moors have to understand. We were stateless and lawless. Therefore, the United States of America were not breaching our rights. Okay, Article 5.
Article 5, 1. Each state party shall take such measures as may be necessary to establish its jurisdiction over any of the offenses set forth in Article 1 which are committed. A. In its territory or on board a ship or aircraft registered in that state. B. By any of its nationals or, if that state considers it appropriate, by those stateless persons who have their habitual residence in its territory. C. In order to compel that state to do or abstain from doing any act, or D. With respect to a hostage who is a national of that state, if that state considers it appropriate. 2. Each state party shall likewise take such measures as may be necessary to establish its jurisdiction over the offenses set forth in Article 1 in cases where the alleged offender is present in its territory and it does not extradite him to any of the states mentioned in paragraph 1 of this article.
Okay, let's pause right there. Listen to this, Morris. This is Article 5, okay, Section 2. Section D, I mean. Okay, Section D. With respect to a hostage who is a national of that state. So the hostage is what? A national of a state.
Yeah.
So if you say you've been kidnapped, you're a hostage, what you're saying is you're a national of a state. Well, how can Moorish Americans be kidnapped or hostage if they're not a national of a state? Because there's no state that recognizes that Moorish American. You know how I know there's no state that recognizes Moorish Americans? Because your Moorish American teacher's been telling you that you are the federal government yourself. All by your lonesome, you the three branches of government, all by yourself. So you're the state, and you're the executive branch, and you're the legislative branch, and you're the judicial branch. All by yourself. You hold all four positions: state, legislator, executive, and judicial branch. You are all four. And this is why the United States of America and their several union states keep giving Moors sanity tests. The Moors are walking in the magistrate's courtroom saying, yeah, I'm the federal government. That's what Moors are saying out loud. This is ridiculous, isn't it? So if you're a hostage, now let's talk about Moorish American. I say this with respect because this is education we're talking about. We have to talk about this. Sometimes the truth is messy. So you saying you're a hostage, you saying you kidnapped. Okay, now tell me, since you say you're the federal government, who are you going to contact in your federal government to come and represent you now that you've been detained? Because you sit in all the seats by yourself. Who are you going to call? Ghostbusters? Who are you going to call, Moorish Americans? Who have you always called?
They're teachers, Moorish American teachers.
Oh, you say Moorish American teachers? Okay, guess what? Moorish American teachers, all of a sudden they change their phone number. All of a sudden they block you. Or they ignore your calls. You don't hear from them no more. Now that you gave them all kind of notes. The same notes they say is fiat and it's fake. They want it. They want that 1,000. They want 2,000. They want 3,000 notes that they say is fake. And you get caught up. After they told you that you're all three branches of government and you are the state, then you get caught up and you reaching out for help to your so-called representative and they disappear on you. But wait a minute. You the one said you're the government. Why are you blaming your Moorish American teacher when you get caught up? They told you you was the government. Why aren't you acting like a government? Where's your government representatives? No, you know what the reality is? You're stateless and you're lawless. And now the United States of America is going to invoke their laws against you because guess what? The United States of America got real laws. There's several union states got real laws. They got real three branches of government. They got law enforcement, they got judges, and they got jails. So good luck with that, Moorish Americans. I love all y'all, but Moorish Americans, and I used to be a Moorish American, suffer from cognitive dissonance. And it don't get real until you get them silver bracelets on your arm. And next you know, you see some jail cell closed behind you, say, man, this is real. And it's sad. Moorish Americans have been injured for years, punitive damages. Because of neglect, they've been miseducated and indoctrinated, and they remain subjugated, and then they end up what? Adjudicated. That's the truth. But check this out. With respect to hostage, who is a national of that state, if that state considers it appropriate, right? So section 2, each state party shall likewise take such measures as may be necessary to establish its jurisdiction over the offenses set forth in Article 1 in cases where, so it's all about jurisdiction, because jurisdiction tells you who has subject matter jurisdiction to hear the case, right? Which laws you get to invoke. And if you get to invoke the law, you get to invoke your judges. That's why the question comes up. Who has subject matter jurisdiction? What does subject matter jurisdiction mean? Who gets to invoke the law that invokes the statutes, right? The rules of engagement, and get to talk about it in their court. The question is, who has home court advantage? You see? Moorish Americans had no state, which means they were stateless, which means they had no home, which means they had no home court advantage, which means automatically they deferred back to the visiting team's laws, rules, and courts. You see how simple that was? Okay, Article 6.
Article 6, 1. Upon being satisfied that the circumstances so warrant, any state party in the territory of which the alleged offender is present shall, in accordance with its laws, take him into custody or take other measures to ensure his presence for such time as is necessary to enable any criminal or extradition proceedings to be instituted. That state party shall immediately make a preliminary inquiry into the facts.
Pause. Okay, Article 6. Upon being satisfied that the circumstances so warrant, any state party in the territory in which the alleged offender is present shall, in accordance with its laws, the state laws, take him into custody or take other measures to ensure his presence for such time as necessary to enable any criminal or extradition. Extradition. What's extradition? Okay.
Send them back to the
Yeah,
state.
that's send them back, right? Okay, well, wait a minute. No.
Extradite. Verb. Hand over. A person accused or convicted of a crime to the jurisdiction of the foreign state in which the crime was committed.
Okay, well, wait a minute. Moorish Americans always fight to get a case, what? Dismissed. They're always fighting for default, right? Default procedure. They want the case thrown out. That's all they fight for. Well, wait. Where's your Moorish American government that's trying to get you extradited back to the jurisdiction in which you say you came from? You say the United States of America don't have jurisdiction, right? Okay, well, what jurisdiction you come from? And why isn't your Moorish American government petitioning, right, under habeas corpus or petitioning to have you extradited back into the jurisdiction that you claim you came from? Where's the government that's doing that for you? There's no Moorish American boilerplates. There's no documents out there with Moorish Americans talking about extradition. It doesn't exist, does it? But look here. It says what? To extradite. Hand over a person accused or convicted of a crime to the jurisdiction of the foreign state in which the crime was committed. Well, wait a minute. Moorish Americans are not asking to extradite for the Moors to come back into their jurisdiction. And the United States of America is not petitioning any Moorish American government to extradite a Moorish American back into the jurisdiction of the United States. Those correspondences don't happen. Well, why is that? It's because Moorish Americans are stateless. There is no state. Moorish Americans are in the absence of a state, in the absence of laws. I'm going to keep hammering this point. This is why Moorish Americans don't talk about any extradition. They don't talk about the word extradite, do they? No. Because they have no state. They have no jurisdiction. What's the jurisdiction then, Moor? Huh? What's the jurisdiction? And then tell me the name of the state. See how easy that was? You don't have no legal argument. You have no legal defense as a Moorish American. Because you're stateless. Let's continue.
2. The custody or other measures referred to in paragraph 1 of this article shall be notified without delay, directly or through the Secretary General of the United Nations. 2. A. The state where the offense was committed. B. The state against which compulsion has been directed or attempted. C. The state of which the natural or juridical person against whom compulsion has been directed or attempted is a national. D. The state of which the hostage is a national or in the territory of which he has his habitual residence. E. The state of which the alleged offender is a national or, if he is a stateless person, in the territory of which he has his habitual residence. F. The international intergovernmental organization against which compulsion has been directed or attempted. G. All other states concerned.
Okay, so the Moroccan states need to adopt language such as this. It's giving specific instructions, right? Specific performance on how you deal with this between two or more states. How do you extradite someone, right? How do you get your own national back, and vice versa? How do you send someone back to a foreign state? This is what Moors were in the absence of. We need to invoke this type of language in dealing with the scenario of hostage taking, right? If we want to accuse the United States of America or the United States or one of their several union states, well, what laws said that they breached of yours? And matter of fact, now that you recognize they breached your law, what is the next step? Okay, now you go through these steps, okay? This is what we're learning here, Moors. We don't have to reinvent the wheel. We just have to be good stewards of understanding international law and then making that Moroccan law. We need both. International law, we flank them, right? We flank the United States of America and the several union states with international law, such as this language. Then we take this same language and we convert it into Moroccan law, says almost the same thing, and then we flank them with that. So we flank them with both. They can't get out of that. These are contracts. These are laws. Okay, let's continue.
3. Any person regarding whom the measures referred to in paragraph 1 of this article are being taken shall be entitled, A. To communicate without delay with the nearest appropriate representative of the state of which he is a national or which is otherwise entitled to establish such communication, or, if he is a stateless person, the state and the territory of which he has his habitual residence. B. To be visited by a representative of that state.
Pause. Okay, Article 3, or Section 3, I should say. Any person regarding whom the measures referred to in paragraph 1 of this article are being taken shall be entitled. So a hostage been taken. A. To communicate without delay with the nearest appropriate representative of the state on which he is a national. Let's read it again. Section A. To communicate without delay with the nearest appropriate representative of the state on which he is a national. Are Moorish Americans reaching out to their state? No. They've been taught to be individual Moors. And the worst part is this. A Moorish American, let's say they get detained, whatever, you know what their teacher or other Moors will say? Oh, you didn't study enough. You're incompetent. That's why you went to jail. You see, your Moorish American teachers are using that as a cop-out because they know they can't help you. They done ran off with your money. Now they can't help you. This is why they keep blaming you. This is why they told you, hey, man, you know, when you sign this paperwork to get your so-called nationality card, we don't have no liability in dealing with you. Once you sign it, it's all on you. Don't call us back blaming us. You just need to study. No. This is criminal. This is criminal what's happening with these Moorish American teachers telling people that they have to get paperwork from your Moorish American teacher in order for your teacher to nationalize you, and then your teacher turn around and tell you, now I have no liability with you. You're on your own now. It's catch and release. You know what they're catching? They're catching the money, but then they release you. It's catch and release. And then you go out and get caught up. And guess what the United States of America and their several union states do? They don't play catch and release, do they? Nah, they catch you and give you a release date from prison. Let's continue.
4. The rights referred to in paragraph 3 of this article shall be exercised in conformity with the laws and regulations of the state in the territory of which the alleged offender is present, subject to the proviso, however, that the said laws and regulations must enable full effect to be given to the purposes for which the rights accorded under paragraph 3 of this article are intended. 5. The provisions of paragraph 3 and 4 of this article shall be without prejudice to the right of any party, any state party having a claim to jurisdiction in accordance with paragraph 1b of Article 5 to invite the International Committee of the Red Cross to communicate with and visit the alleged offender.
Okay,
Article
Paul.
7. The state party where the alleged offender is prosecuted shall, in accordance with its laws, communicate the final outcome of the proceedings to the Secretary General of the United Nations, who shall transmit the information to the other states concerned and the international intergovernmental organizations concerned.
Okay, pause right there. So let's read this again. Article 7. The state party where the alleged offender is prosecuted, right? So wherever the offender is prosecuted, right? Let's say the Moroccan state government prosecutes an American, right? So we're the ones prosecuting the offender, okay? So it says, Article 7, the state party where the alleged offender is prosecuted shall, in accordance with its laws, communicate the final outcome of the proceeding to the Secretary General of the United Nations. All right? So if we prosecute an American for holding one of our Moroccan nationals hostage, once we get done prosecuting him, we have to notify the Secretary General, because they're keeping a record of who's been performing what? Terrorist acts. You see? Terrorist acts. So the United Nations is keeping a record who's been acting like terrorists. You see? So the United States is very familiar. They understand once these Moors get back in the statehood and the Moors start to enact their statutes, right? Their laws, their legislation, and if the Moors' laws and legislation, right, and statutes have something about hostage taking, and we enforce that against America, right, and we turn around and prosecute an American for holding one of our Moors as hostage because we said that's a terrorist act, the United States knows we have to notify the Secretary General, and guess what the Secretary General going to do? It's going to tell the United States, oh, you acting like terrorists? Keep it up, and we're going to put your name on the terrorist list. There's a terrorist list. The United States don't want their name on the terrorist list. Trust me when I tell you. Now, the United States love to put other states on the terrorist list. They love to put bad actors on the terrorist list because they get to put sanctions on them and all this stuff, right? The United States don't want to be on the terrorist list. But that's exactly where they're going to end up if we start to prosecute them, right? With what? Our laws. Listen, let's read it again. Article 7, the state party where the alleged offender is prosecuted shall, in accordance with its laws, whose laws? The state laws, right? The state laws, okay? The state laws communicate the final outcome of the proceedings to the Secretary General of the United Nations, who shall transmit the information to other states concerned and the international intergovernmental organizations concerned. You see that? So the United Secretary General can let all other states on planet Earth know that these Moroccan Moors, i.e. just simply Moroccan nationals through their 3 branches of government, and now they're utilizing their judicial branch, right, which is the consular court. Consular court now has found this American to be guilty of performing a hostage act because he was an offender, right? Now he becomes a respondent. We prosecute him. Then we notify the Secretary General, hey, we have to prosecute an American who was trying to hold on to one of our Moroccan nationals under a hostage status. Okay? Now we update the Secretary General, and guess what the Secretary General has the right to do? Let all other states know about that terrorist act. You see what's happening? Now the United States will get exposed. Eventually, their name going to end up on a terrorist watch list. They don't want that. Okay, Article 8.
Article 8, 1. The state party in the territory of which the alleged offender is found shall, if it does not extradite him, be obliged without exception whatsoever, and whether or not the offense was committed in its territory, to submit the case to its competent authorities for the purpose of prosecution through proceedings in accordance with the laws of that state. Those authorities shall take their decision in the same manner as in the case of any ordinary offense of a grave nature under the law of that state.
Okay, Article 8. The state party in the territory in which the alleged offender is found shall, if it does not extradite him, so if the United States tries to hold on to that American, right, and say, we don't want to extradite him over into the Moroccan jurisdiction. We don't want to hand him over to the consul general of the Moroccan state. Because they know the consul general is going to hand him over to what? The consul court, right? To be adjudicated. Okay, let's get the proper context. If the American, the United States of America, and then several union states don't want to extradite that American over into our jurisdiction, here's what happens. Okay, Article 8. The state party in the territory in which the alleged offender is found shall, if it does not extradite him, if you don't send him over to the Moroccan government, be obliged without exception whatsoever, and whether or not the offense was committed in its territories, to submit the case to its competent authorities for the purpose of prosecution through proceedings in accordance with the laws of that state. So what's happening? The United States of America's federal courts will be obligated to prosecute that offender. So if the United States don't want to extradite him back into our jurisdiction, the United States of America will be obligated to do what? Prosecute that offender. Okay? Now, that would be a violation of our own Moroccan treaties, because our treaties say, bilateral treaty of peace and friendship says what? Article 20 says, any dispute between a Moor and a citizen shall be decided by who? The consul court. That's Moors. So no, we're not going to leave it up to the United States to prosecute one of their own. That'd be a violation of the treaty. No, United States. You're going to extradite them to us. Because our treaties already say that the consul court shall have the final decision. But also our Moroccan courts, our Moroccan laws will say you have to extradite them. Because the Moors need to invoke and write or draft a bill that says the United States shall do X, Y, and Z regarding the taking of hostages. And one of those X, Y, and Z may be what? The fact you got to extradite them to us, or that's going to be once again a what? A breach of our Moroccan laws. Because of the breach of what? The treaty. Article 20, the Treaty of Peace and Friendship. You see how easy this is? That way the United States knows they ain't going to be able to get away with their belligerents trying to hide one of their offenders who's offended our rights, of our state rights. You get it? Okay, let's read it again. Article 8.
Article 8, 1. The state party in the territory of which the alleged offender is found shall, if it does not extradite him, be obliged without exception whatsoever, and whether or not the offense was committed in its territory, to submit the case to its competent authorities for the purpose of prosecution through proceedings in accordance with the laws of that state. Those authorities shall take their decision in the same manner as in the case of any ordinary offense of a grave nature under the law of that state.
So in other words, the United States they would normally have to deal with a very serious matter, right? But we're not going to give them the option of prosecuting their own. You're going to extradite them. Why do I say that? Because our Moroccan law say that. Our state statute says that. Our legislative act says that. Our Moroccan state law says you shall extradite. Ain't no, well, we'll think about it. No, you're gonna send them over. We're gonna prosecute them. All right, according to our state laws. Okay. This is going to start slowing down the United States of America and the several Union states' belligerence against Moroccan Moors. Now remember what I said, is Moroccan Moors the same thing, right? It's just Moroccan nationals, period. Okay? All right, Section 2.
Section 2. Any person regarding whom proceedings are being carried out in connection with any of the offenses set forth in Article 1 shall be guaranteed fair treatment at all stages of the proceedings, including enjoyment of all the rights and guarantees provided by the law of the state and the territory of which he is present.
All right, in other words, that's called a human rights clause.
Mm-hmm.
So even if an American does something, they're in our possession, right? We're holding them, right?
Mhm.
They've been indicted for what? Taking a hostage, taking a Moroccan national. We still have to extend certain privileges and rights to that detainee,
Right.
right? So Section 2 says, any person regarding whom proceedings are being carried out in connection with any of the offenses set forth in Article 1 shall be guaranteed fair treatment at all stages of proceedings, including enjoyment of all the rights and guarantees provided by the law of the state in the territory which he is present. That's a human rights clause, you see? Got to treat people with respect no matter what. Okay, Article 9.
Article 9. 1. A request for the extradition of an alleged offender pursuant to this convention shall not be granted if the requested state party has substantial grounds for believing A. That the request for extradition for an offense set forth in Article 1 has been made for the purpose of prosecuting or punishing a person on account of his race, religion, nationality, ethnic origin, or political opinion, or B. That the person's position may be prejudiced. 1. For any of the reasons mentioned in paragraph A of this paragraph, or 2. For the reason that communication with him by the appropriate authorities of the state entitled to exercise rights for protection cannot be effected.
All right, so in other words, you can't discriminate against someone, okay? All right, that's what that means. Okay, Section 2.
Mm-hmm. With respect to the offenses as defined in this convention, the provisions of all extradition treaties and arrangements applicable between states parties are modified as between states parties to the extent that they are incompatible with this convention.
So if the two states got together and put together a contract that has language in it that kind of silences this convention, right? So let's say two states get together and talk about extradition. But the extradition that they wrote between those two states violates this, right? Because it supersedes it, then that language is basically null and void. All right? States should have a right to extradite. And if they can't get you to extradite, then that means that other states should prosecute that offender. They should. But the violation should not go without being punished one way or another. All right? And this is what this is saying there needs to be a prosecution. There needs to be a punishment. There needs to be a sentence handed out for that particular act of hostage taking. Don't let it slide. That's what this is saying. Don't write something in your laws that says, oh, we just going to cancel each other out. We ain't going to do nothing about it. Don't write a treaty or a law that says, don't worry about it. No. This is a grave crime. This is what we're learning. They use the word grave concern, a grave crime. It must and shall be punished. That's what the United Nations is saying. Because if you don't punish, what's going to happen? It'll get out of control, won't it? It must be punished. So the United States of America knows they do something as a terrorist act and hold one of our nationals as a hostage. They already know we have no choice but to do what? Prosecute and punish them for doing so. You see what this says?
Mm-hmm.
You got to catch what it's saying. Okay, let's read it again.
2. With respect to the offenses as defined in this convention, the provisions of all extradition treaties and arrangements applicable between states parties are modified as between states parties to the extent that they are incompatible with this convention.
That means people shall be punished. Don't write something that says we're going to let stuff slide. Okay, Article 10.
Article 10. 1. The offenses set forth in Article 1 shall be deemed to be included as extraditable offenses in any extradition treaty existing between states parties. States parties undertake to include such offenses as extraditable offenses in every extradition treaty to be concluded between them.
Pause. Okay, are you catching a trend here? If the Moorish Americans kept saying that they were kidnapped and they were hostages, then who got extradited for that crime, Moorish Americans?
Mm-hmm.
Huh? Moorish Americans say they've been kidnapped and hostages for decades. Okay, Moorish Americans, I have a question for you. Who got extradited? Tell me the name of the American that got extradited over to your Moorish American state jurisdiction and y'all adjudicated them, punished them, and sentenced them. Tell me when did that happen? Show me the case law, Moorish Americans. Show me the case law where your Moorish American courts found an American official guilty for holding you hostage, right? Because you were the victim, and your Moorish American state government came in and prosecuted that American for holding you hostage. Show me that case law. It don't exist, do it?
No.
You see this trend? It's about prosecution. It's a grave crime. Well, if it's so grave, then where are the Moorish American case laws where they held the Americans to the standards of international law for violating your periphery norms of international law, which is your human rights? Where is it? Where's the case law? All thing Moore's been taught is, yeah, man, try to get it dismissed. Default judgment. And after you get it dismissed, you get all happy because you ain't got no counterclaim, because you don't know how to turn around and now bring them into your state court and adjudicate them for the crime of hostage taking. Let's just tell the truth. We didn't know what the heck we was talking about. Okay, Article 10 from the top.
Article 10:1. The offenses set forth in Article 1 shall be deemed to be included as extraditable offenses in any extradition treaty existing between states parties. States parties undertake to include such offenses as extraditable offenses in every extradition treaty to be concluded between them. 2. If a state party which makes extradition conditional on the existence of a treaty receives a request for extradition from another state party with which it has no extradition treaty, the requested state may at its option consider this convention as the legal basis for extradition in respect of the offenses set forth in Article 1. Extradition shall be subject to the other conditions provided by the law of the requested state.
Did you hear that?
Yes, they're saying.
So international law is already telling Moors, you could have used this international law treaty as your legal defense, even in the absence of your own internal Moroccan laws.
Yeah.
You see, that's a safety net. Why? Because the taking of hostages is a grave crime and it shall be punished. So therefore, if two or more states don't have an extradition contract between the two of them, they can automatically invoke this treaty. Why didn't the Moors know about this? It's because your Moorish American teachers didn't teach you about international law. Well, they can't teach you about international law because you're stateless. International law is only for who? State parties. And you were stateless, and that made you lawless. Section 3.
3. States parties which do not make extradition conditional on the existence of a treaty shall recognize the offenses set forth in Article 1 as extraditable offenses between themselves, subject to the conditions provided by the law of the requested state. 4. The offenses set forth in Article 1 shall be treated for the purpose of extradition between states parties as if they had been committed not only in the place of which they occurred, but also in the territories of the states required to establish their jurisdiction in accordance with paragraph 1 of Article 5. Article 11:1 states parties shall afford one another the greatest measure of assistance in connection with criminal proceedings brought in respect of the offenses set forth in Article 1, including the supply of all evidence at their disposal necessary for their proceedings. 2. The provisions of paragraph 1 of this article shall not affect obligations concerning mutual judicial assistance embodied in any other treaty.
Pause. Okay, Article 11. States parties shall afford one another the greatest measure of assistance in connection with criminal proceedings brought in respect of the offenses set forth in Article 1, including the supply of all evidence at their disposal necessary for the proceedings. So the United States of America got to give us the evidence because they know they've done something. One of their Americans have done something to do what? To break our laws, right? To breach our laws. Because they held one of our Moroccan nationals hostage. Now wait a minute. Who's been holding our Moors hostage? Well, more than likely it's been typically what? The county jails, right? And prisons. The magistrates won't let you post bond, right? And they force you into collusion of parties back into their jurisdiction and enforce their extraterritorial laws against you. So what happens now, they try to detain you and you're a Moroccan national. And we reach out and let them know, excuse me, you're holding one of our Moroccan nationals. That's a violation of our Moroccan laws, because our Moroccan law says in any dispute, you need to extradite them back to us. That way we can now take this dispute to consular court. If you got a dispute, no worries, but you shall release them immediately back into our hands or our jurisdiction, and then you can bring your civil or criminal dispute to consular court. But in the interim, you shall not hold on to them. But if you continue to detain them after this particular date, automatically we're going to put you in a different status of what? Genocide, right? Terrorism, right? Hostage taking. And we let them know that you're about to elevate to a different status if our national is not released immediately. Because you're trying to use collusion, right, of the parties to pull them back into your jurisdiction as Americans. They're not Americans. These are Moroccan nationals. So this is what's happening, okay? So in other words, who's going to end up being alleged hostage takers? It's going to end up being the police, the sheriff, the prosecutor, the magistrate. It's going to end up being the mayor and the governor, because we're going to notify all these people of our Moroccan laws. If they don't use any type of clemency, right? Immediate release, extradition, right? If they don't pardon, if they don't do something to stop it, immediately that's going to be a breach of our laws. That must be understood. We're going to invoke Moroccan laws against them immediately. And once we notify all their principals who are in charge, immediately they're going to be considered to be what? Accomplices, right? Accomplices in hostage taking. An accomplice in genocide. An accomplice of a terrorist act. And we're going to give them notification well in advance. We're going to send them a copy of our laws. Hey, just want to let you know, here's what the law says. Anything after this date shall be considered whatever it is we said in this particular statute, in this particular law, this particular legislation. And Moroccan law is applicable to the United States of America. They're subject to Moroccan laws. Why? Because they're in Morocco. Okay, Article 12.
Article 12, insofar as the Geneva Conventions of 1949 for the protection of war victims or the protocols additional to those conventions are applicable to a particular act of hostage taking, and insofar as the states parties to this conventions are bound under those conventions to prosecute or hand over the hostage taker. The present convention shall not apply to any act of hostage taking committed in the course of armed conflicts as defined in the Geneva Conventions of 1949 and the protocols thereto, including armed conflicts mentioned in Article 1, Paragraph 4 of Additional Protocol 1 of 1977, in which peoples are fighting against colonial domination and alien occupation and against racist regimes in the exercise of their right of self-determination as enshrined in the Charter of the United Nations and the Declaration on Principles of International Law concerning friendly relations and cooperation among states in accordance with the Charter of the United Nations.
All right, that is a mouthful. Let's talk. Okay, here we go. As you can already heard, this is about what? Decolonization. Right? Well, let's read. Article 12. Insofar as the Geneva Convention of 1949, more need to know about that, for the protection of war victims, because that's talking about war, right? Because international law talks about times of peace and times of war. Okay, so if there's an actual war going on, now you invoke this. Why? Because the colonists might end up warring against us because these are acts of terrorism. Now it goes from an act of terrorism to a full-fledged act of war. You see, now because it's an act of aggression against us. As soon as it hits an act of aggression, typically that's an act of war. And that's what the Moroccans need to put into their laws. If this is an aggressive act, and it meets a certain criteria that we define in our laws of aggression, immediately we can say that's an act of war. As soon as it becomes an act of war, now we can invoke the Geneva Conventions. You see, you gotta understand, there's times of peace when stuff is happening and times of war, but these things escalate. Listen, Article 12. Insofar as the Geneva Convention of 1949 for the protection of war victims, or the protocols additional to those conventions are applicable to a particular act of hostage taking, and insofar as states parties to the convention are bound under those conventions to prosecute or hand over their hostage takers, the present convention shall not apply to an act of hostage taking committed in the course of armed conflicts as defined in the Geneva Convention of 1949 and the protocols thereto, including armed conflicts mentioned in Article 1, Paragraph 4 of Additional Protocol of 1977, in which peoples are fighting against colonial domination and alien occupation and against racist regimes in the exercise of their right of self-determination. Pause. So we take Americans and we detain them because we're in war. When America can't say that, oh, well, you took our Americans, locked them up. That's an act of hostage taking. No, America. You can't say that because we detained Americans that we took them as hostages. No. That's an act of war, right? So in war, there's no hostages. However, the United Nations recognizes that if, in fact, the colonists start a war, right, the indigenous people, the inhabitants, i.e. the Moroccans, have certain rights. That means we can detain their people in the midst of war. You see? They become what? Political prisoners for the most part, not hostages. Okay, so continue to read. So as the right of self-determination as enshrined in the Charter of the United Nations, there they talk about that Charter of the United Nations again, and the Declaration on Principles of International Law concerning friendly relations and cooperation amongst states. That's the 1970 United Nations resolution, right? Resolution 2625, in accordance with the Charter of the United Nations, okay? Article 13.
Article 15.
13.
Or 13. This convention shall not apply where the offense is committed within a single state. The hostage and the alleged offender are nationals of that state, and the alleged offender is found in the territory of that state.
Pause, read it again.
This convention shall not apply where the offense is committed within a single state. The hostage and the alleged offender are nationals of that state, and the alleged offender is found in the territory of that state.
Read it again.
This convention shall not apply where the offense is committed within a single state. The hostage and the alleged offender are nationals of that state, and the alleged offender is found in the territory of that state.
What's the interpretation?
Moorish Americans.
Moorish Americans keep saying they hostages and kidnapped, but Moorish Americans are citizens of the United States. They've been detained by citizens of the United States. So therefore, that's an American on American dispute. Hostage taking is only when a foreign state has detained you. But first, you have to be a national of your own state in the first place. So my question to Moorish Americans is this. Tell me the name of your Moorish American state that recognizes you as one of its nationals. Prove it. Well, if you can't prove that, that means by default, you are still a citizen of the United States. And the United States is not kidnapping you. You're not a hostage. You're just simply detained, arrested, and adjudicated by the United States as being an American of the United States. It's an American on American civil domestic dispute. However, once you pledge your allegiance to a Moroccan state and the state recognizes you as being a Moroccan national, now you have a dispute between a Moroccan and an American. So therefore, if Americans hold you as a hostage in their jurisdiction, now you're considered a hostage. Now you've been taken as a hostage. Now you've been kidnapped by what? A foreign state. Let's read it again. Article 13. This convention shall not apply where the offense is committed within a single state. The hostage and the alleged offender are nationals of the state, the same state. And the alleged offender is found in the territory of that state. Why do the Moorish Americans know this? But man, we have been hoodwinked, bamboozled, and led astray. Our Moorish American teachers told us that we were kidnapped, and that's not true. It's just not true. The only time it becomes true if you pledge your allegiance to a Moroccan state, then it becomes a legal argument and a legal defense to say that you are a Moroccan national because you're recognized by your state. In the meantime, it's just an American on American dispute, and according to Article 13, you can't say that you've been kidnapped or that you are a hostage within the same state that you're a resident of. Come on now, Moors. This is shameful. Article 14.
Article 14. Nothing in this convention shall be construed as justifying the violation of the territorial integrity or political independence of a state in contravention of the Charter of the United Nations. Article 15. The provisions of this convention shall not affect the application of the treaties on asylum in force at the date of the adoption of this convention, as between the states which are parties to those treaties. But a state party to this convention may not invoke those treaties with respect to another state party to this convention, which is not a party to those treaties.
Okay, you got to become parties to the treaties, Moors, but you can only become party if you're a state. Continue.
Article 16.1. Any dispute between two or more states parties concerning the interpretation or application of this convention, which is not settled by negotiation, shall, at the request of one of them, be submitted to arbitration. If within 6 months from the date of the request for arbitration, the parties are unable to agree on the organization of the arbitration, any one of those parties may refer the dispute to the International Court of Justice by request in conformity with the statute of the court. 2. Each state may, at the time of signature or ratification of this convention or accession thereto, declare that it does not consider itself bound by paragraph 1 of this article. The other state's party shall not be bound by paragraph 1 of this article with respect to any state party which has made such a reservation.
Okay, so Article 16 says what? If the Moroccan states are having a problem with the United States, we can invoke Article 16 because we became a party to this. Now we said under Article 16, we can contact the United Nations and say, look, we need an arbitrator to come in. Do you have a special committee, United Nations, that you can bring in and act as arbitrators, right? But what else can we bring in? We can bring in the Wazir Regional Council. Let's say your Moroccan state, right? Let's say like AMPAC, right? Elodium Morris Pretium Ante Colorado is having a problem with the state of Colorado, right? And the United States, okay? Now the Wazir Regional Council can come in as arbitrators, right? So the Wazir Regional Council, okay, can come in as arbitrators, right? As a third party to try to assist with negotiations, right? They come in as a third party, okay? And that must be understood. Not only can we contact the United Nations, but we can also start regionally. Instead of going to the United Nations, let's start with our own Moroccan intergovernmental organization, which is a regional, i.e. international organization, i.e. intergovernmental organization, because it represents the central government of the Empire of Morocco. So you can bring in the WRC to try to deal with as arbitrators to assist with negotiations. Okay, let's go back to it. All right, so Article 16, any dispute between two or more states parties concerning the interpretations or application of this convention shall, which is not settled by negotiation, shall at the request of one of them be submitted to arbitration, and within 6 months from the date of the request for arbitration, the parties are unable to agree on the organization of the arbitration, any one of those parties may refer the dispute to the International Court of Justice for a request in conformity with the statute of the court. You see that?
Mm-hmm.
So within 6 months, if we petition, the arbitrators come in, if the negotiations break down and arbitration does not prevail, then we must do what? Contact International Court of Justice. However, what does our treaty say first? What do we do first? First, we got to do what? Settle it through the consular court.
Mm-hmm.
So you let the arbitrators do their first part, right? That's your political settlement. If you can't settle it politically with some type of negotiation, mediation, conciliation, right, arbitration, then you can do what? Judicial settlement. That would be consular court first. Consular court still does not prevail because the United States is still being a belligerent, or there's several union states, then we take it automatically where? To the International Court of Justice. Because the International Court of Justices will want to see all the documentary evidence leading up to it. They'll want to see what the actual infraction is, right? I.e. the dispute, the contentious dispute. They'll want to see all the correspondence that went back and forth regarding the dispute. They'll want to see the arbitration correspondence that went back and forth. Ultimately, they'll want to see the consular court order, right? Judgment or opinion. And if that didn't prevail, they see the consular court even issued a contempt of court order, and the belligerent state still did not adhere. Now the ICJ gets involved and they review all of that. You see, documentary evidence. Now the ICJ will make a ruling because the ICJ, according to Article 16, has what's called ipso facto compulsory jurisdiction over the matter, because we've signed this contract and allowed the ICJ to come in and adjudicate, right, over the case, right, to have some type of finding that way, create some type of nature of relief for each party. Okay? All right. Section 3.
Section 3. Any state party which has made a reservation in accordance with paragraph 2 of this article may at any time withdraw that reservation by notification to the Secretary General of the United Nations.
So you can notify the United Nations you want to take their name off the contract. Okay? 17.
17.1. This convention is open for signature by all states until the 31st of December of 1980 at the United Nations headquarters in New York. 2. This convention is subject to ratification. The instruments of ratification shall be deposited with the Secretary General of the United Nations. 3. This convention is open for accession by any state. The instruments of accession shall be deposited with the Secretary General of the United Nations. Article 18. 1. This convention shall enter into force on the 13th day following the date of deposit for the 22nd instrument of ratification or accession with the Secretary General of the United Nations. 2. For each state ratifying or acceding to the convention after the deposit of the 22nd instrument of ratification or accession, the convention shall enter into force on the 13th day after deposit by such state of its instrument of ratification or accession.
All right, thank you very much. So what's this all about? Article 17 through 18, right, is talking about what?
Ratified deposit.
And promulgation, right? So this is about what? Constitutional procedures.
Mm-hmm.
What does constitutional procedure mean? It means you bring this particular treaty back, and you do what? You pass it through the legislative branch as a bill. And that bill gets accepted, right? It gets voted on by the matriarchal council of your legislative branch. And they vote yes on it to pass it as a bill. They ratify it. It's a ratification sent from the legislative branch over to, they pass it to who? The executive branch. Then the executive branch is the head of state, i.e. the wazir, signs his name to it, and then do what? It enters into law. It becomes what? It becomes what? A statute. It becomes what? Legislation. It becomes what? Law, i.e. what? It becomes Moroccan state law. You see? And this is what the Moors were in the absence of. We did not understand governments. We did not understand constitutional procedures. It's because the Moors were in the absence of a competent constitution that recognized 3 branches of government.
Yep.
Good brother Noble Drew Ali did not have three branches of government even in his constitution. He made best efforts, right? He was just trying to get the Moors going in the right direction, right? CM Bay wrote a constitution, right? The Zodiac Constitution. It did not have three branches of government. So Moors have been trying to write constitutions, but unfortunately we've been slacking in understanding what is a constitution all about. Well, a constitution is about four things. What is a constitution about? Well, first of all, it's about claiming a permanent population. 2, claiming a permanent land mass. 3, what? Having a government, 3 branches of government. And number 4, the ability to enter into relations with other states. Well, we didn't have a state, right? Noble Drew Ali's constitution was turned into a church bylaw. And a temple is not a state. Don't even get me started. I'm just going to keep it simple like that. I'm not even going to venture into that. The reality is the Moorish Americans are stateless people. Because first of all, there's no such thing as Moorish Americans. You've grafted 2 different nations' names according to the bilateral treaty. There's Moroccans and Americans, and you grafted and turned it into a Frankenstein. You've turned it into a third-party interloper. You've turned it into a connotative linguistic. And that's the truth. There's no such thing as a cherry apple tree. It's either a cherry or it's apple. Choose one. Article 19.
Article 19.1. Any state party may denounce this convention by written notification to the Secretary General of the United Nations. 2. Denunciation shall take effect 1 year following the date on which notification is received by the Secretary General of the United Nations. Article 20. The original of this convention, of which the Arabic, Chinese, English, French, Russian, and Spanish texts are equally authentic, shall be deposited with the Secretary General of the United Nations, who shall send certified copies thereof to all states. In witness whereof, the undersigned being duly authorized thereto by their respective governments have signed this convention, open for signature, at New York on the 18th of December of 1979.
All right, and that's the end of the reading. All right, so the Moors should think about maybe becoming parties to this. They need the legislative branch and the executive branch of your state needs to talk about the language of it. If you don't want to become parties to it, at least copy paste the language out of it and turn it into Moroccan law and make whatever changes you want to it. But at least if you are Moroccan law, that still governs the United States of America, because the United States of America comes under Moroccan law. They're subject to Moroccan law because Moroccan law has what's called subject matter jurisdiction. Mm-hmm. The subject matter is Moroccan law. Mm-hmm. The land is Morocco, right? The land is Morocco. Let's talk about that, okay? I'm going to switch gears here slightly, okay? Switching gears, okay. This is George Washington's letter, okay? First of all, this is the Founders Online, National Archive. Moors know about this. It's George Washington. It's about his letter, right, from George Washington to the Emperor of Morocco, right, 31st of March, 1791. Not 1789, but 1791. Why am I pulling this up? Because y'all notice when we were reading over the convention, the United Nations Convention, it kept talking about stateless person, right? We saw that terminology, right? So if Moorish Americans are stateless persons, how is it that law is still recognizing them as stateless persons? Because they're still a person, right? They're just stateless. But what type of person are they actually? They got to belong to somebody. It's somebody's child running around, right? That either they don't know who their mother is, or the mother hasn't recognized the child. The child's been lost and found, right? So we need to take a moment and get an understanding of who the Moorish Americans actually are, right? Because I want to help the Moorish Americans. I want to help them to return back to Morocco because Moorish Americans think they're not Moroccans, and that's furthest from the truth. You are Moroccans. But the reality is, laws have recognized you as being a subject. And what I learned about Moorish Americans, they think only black people are subjects. They think that they are nationals, and that's not true. You're not a national. Moorish Americans are not nationals. Just because you got a nationality card in your head, your pocket, your nationality card is fictitious. You did not have it given to you by your state officials. You got it from Ari Bay Publications. You got it from the temple. You got it from something other than a state that has three branches of government, and that constitution has been ratified, deposited, and promulgated in accordance to international law. If you have a nationality card from anything other than a Moroccan state, it is fictitious. Which means you're still a subject, no different than the Blackamoors. You Moorish Americans and Blackamoors are the same thing. It's the same definition because both of them are stateless people. They're Moor subjects. Let's prove it, because we just finished talking about hostage negotiations. But how you end up being a hostage if you're not a national? So let's talk about what is the true status of Moorish America. Got to show you some reference points. All right? Let's spend a little while on this real quick. In order for you to finally be able to invoke the fact that you actually been taken as a hostage or kidnapped, first you got to know who you are. Okay? Now this is what you call political correspondence. Between who? The United States of America, which is a state that was recognized by Sidi Muhammad, because George Washington deposited their Constitution, United States of America, on December 1st, 1789 with the Sultan. The Sultan accepted their Constitution that recognized them as being Americans of the United States of America. And the Sultan at the time was representing the Empire of Morocco. Okay? Now, I want to show the Moors about this word subject. We got to talk about this word subject because Moors are confused. Okay, let's start from the top.
To the Emperor of Morocco, great and magnanimous friend of 31st of March of 1791. Separated by an immense ocean from the more ancient nations of the earth and little connected with their politics or proceedings, we are late in learning the events which take place among them, and later in conveying to them our sentiments thereon. The death of the late emperor, your father, and our friend of glorious memory, is one of those events which, though distant, attracts our notice and concern. Receive, great and good friend, my sincere sympathy with you on that loss, and permit me at the same time to express the satisfaction with which I learn the accession of so worthy a successor to the imperial throne of Morocco, and to offer you the homage of my sincere congratulations. May the days of your majesty life be many and glorious, and may they ever mark the era during which a great people shall have been most prosperous and happy under the best and happiest of sovereigns.
Okay, pause right there. So the first paragraph, this is what George Washington says in 1791. He says, separated by the immense ocean from the more ancient nations of the earth, and little connected with their politics or proceedings, we are late in learning the events which take place among them, and later in conveying to them our sentiments thereon. Right, so we're talking politics. Two different nations. George Washington is the head of state, is sending a letter over to what? The head of state. And the state at that time was the Empire of Morocco, because they had a sultan representing the Empire of Morocco. That's why he's an emperor representing an empire. Okay? So now George Washington's concerned because the sultan died, Sidi Muhammad's dead, and his son has taken over the throne. He's scared his son gonna do what? Terminate that bilateral treaty that George Washington and the Continental Congress had signed in 1786 and fully ratified in 1787. And then George Washington writes a letter to Sidi Muhammad in 1789. Then he finds out that Sidi Muhammad has died in 1791. He's like, oh Lord, what is his son gonna do? Now his son is the sultan. Is his son gonna honor the treaty? What's my point here? Two separate nations. Two separate nations. Americans, Moroccans. Okay? Now listen to this part right here. Okay? Here we go.
The late emperor, very soon after the establishment of our infant nation, manifested his royal regard and amity to us by friendly and generous acts, and particularly by the protection of our citizens in their commerce with his subjects.
Paul, read it again.
The late emperor, very soon after the establishment of our infant nation, manifested his royal regard and amity to us by many friendly and generous acts, and particularly by the protection of our citizens in their commerce with his subjects.
Read it again.
The late emperor, very soon after the establishment of our infant nation, manifested his royal regard and amity to us by many friendly and generous acts, and particularly by the protection of our citizens in their commerce with his subjects.
So the United States citizens, right, in their commerce with the Sultan's subjects. Well, who are the subjects? That's the Moors. So George Washington's writing this letter saying, us citizens are in the commerce with your Moroccan subjects, Moorish subjects. You see what George Washington's writing? He's recognizing two different parties, isn't he? In this letter of 1791. So Moors are what? Subjects. You see that? Let's read it again. Just move. Let's read it again. It's George Washington. Okay, from the top.
The late emperor, very soon after the establishment of our infant nation, manifested his royal regard and amity to us by many friendly and generous acts, and particularly by the protection of our citizens in their commerce with his subjects, and as a further instance of his desire to promote our prosperity and intercourse with his realms.
Pause. Read that sentence again.
And as a further instance to his desire to promote our prosperity and intercourse with his realms.
Continue.
He entered into a treaty of amity and commerce with us for himself and his successors to continue 50 years. The justice and magnanimity of your majesty leave us full of confidence that the treaty will meet your royal patronage also, and it will give me great satisfaction to be assured that the citizens of the United States of America may expect from your imperial majesty the same protections and kindness, which the example of your illustrious father has taught them to expect from those who occupy the throne of Morocco, and to have our royal word, that they may count on a due observance of the treaty which connects the two nations in friendship.
So there is two nations. There is two nations in friendship. Who are the nations? Moroccans, Americans. And the treaty is providing protection for who? The Empire of Morocco is protecting who? Americans and Moroccans. And the Moroccans at that time were called what? Subjects. Subjects. Moorish subjects. And the treaty is protecting both of those parties under the Treaty of Amity, right? Amity means friendship, right? Tranquility, peace. It's two nations. But you know what the Moorish Americans did? They combined two nations into one name called Moorish American. Moorish means Moroccan. So you're saying you're a Moroccan American. Ain't no such thing. You're either a Moroccan or you're American. Now don't get me wrong. The word American is assessed to Moorish Americans because they continue to recognize their adopted mother. Their adopted mother, last name is American. So you became Moroccan American because you ended up being stateless because the United States of America naturalized you. What does naturalized mean? They adopted you. They adopted you. They became your legal guardian and gave you the last name of American. But the reality is you've always been Moroccan, but you got to let go of the surname. You got to let go of the adopted name, just simply be Moroccan. You got to choose between the entire submission to the laws of what? The Moroccan Empire, Moroccan government, which means you can no longer be what? American. But the Moorish Americans are forcing this third-party interloper, connotative misnomer, which is the corruption of this right here. Two nations in friendship. Then tell me who the two nations are. But I've heard Moorish American teachers say Moorish American is the same. The American and Morocco is the same. They're not making any distinctions. That's a subjugation mindset. They want to remain under the jurisdiction of America. But that's all right. Stay over there and call yourself American, but you're not Moroccan anymore. Accept your subjugation status as Americans. But stop saying you're Moorish Americans, because that's a corruption of the fact that Moors are trying to return to Morocco and you're pretending to be halfway crooks. Either you return fully, right? Because the Treaty of Madrid, Article 15, paragraph 1 says you must do what? Return to what? The entire. You must choose the entire submission to the laws of the empire. Which means you got to let go of the status of American. And this is what we're being taught. We're being taught that we're both parties, and we're not. Let's continue the last reading of it.
This will be delivered to your majesty by our faithful citizen Thomas Barclay, who I name consul for the United States in the dominions of your majesty, and who to the integrity and knowledge qualifying him for that office unites that peculiar advantage of having been the agent through whom our treaty with the late emperor was received. I pray your majesty to protect him in the exercise of his functions for the patronage of the commerce between our two countries and of those who carry it on. May that God, whom we both adore, bless your imperial majesty with long life, health, and success, and have you always great and magnanimous friend under his holy keeping. Written in Philadelphia, the 31st day of March, in the 15th year of our sovereignty and independence, from your God and your good and faithful friend, George Washington, by the President Thomas Jefferson.
All right, so George Washington was concerned that the prince turned king, sultan was going to terminate the treaty. Mm-hmm. And if the sultan would have terminated the treaty, then the 13 colonies would have been right back in a war with Great Britain, because Great Britain was still considered the 13 colonies as treasonous, right? Because they no longer wanted to consider themselves British anymore. They were going under the name of American, and the American was recognized by Sidi Muhammad. The word America is recognized by the Empire of Morocco through the treaty relations. So Sidi Muhammad, right, recognized the Americans as being Americans. And the Americans recognized the land as being the Empire of Morocco. The 13 colonies knew they was seeking asylum in the dominions of Morocco. Right? Well, what's my point here? Okay, what's my point? My point is this right here. There are two different legal personalities. There's citizens, and who are the citizens? Americans. Okay, who are the subjects? Who are the subjects? Moroccans. There were more subjects, but Moorish means what? Moroccan, because it's more rocking. Okay? Now, why am I pointing that out? Okay. Here we go. Let's go over to now the Constitution of the United States, right? Of 1871. That's not the Constitution of the United States of America of 1789. This is not George Washington's Constitution. This is the sellout bankers' Constitution. And the bankers got the United States of America to sell themselves out to the bankers after the Civil War. So in 1871, they created the Constitution of the United States. And all the judges, the president, the legislative branch, all of them agreed to create the United States. They all sold out the United States of America. They sold out George Washington. That's the truth. But in this Constitution, what's my point? Okay, so there's the preamble, okay? The Constitution of the United States recognizes three legal personalities. In Article 1, Section 2, in Article 1, Section 8, it recognizes who? Okay, let's go down to it. All right, let's go down to it. Article 1, Section 2. Okay, it represents who? You see that word? Indians. Indians. Okay, Indians. See that? Okay. So it recognizes Indians as a legal personality in Article 1 of their Constitution. Okay? Now, if you scroll down, that's Article 1, Section 2, okay? Article 1, Section 2 recognizes this word called Indian. Okay? Now if you scroll down, now you go down to Section 8, okay? Section 8 also recognizes the word Indian, all right? Indian, okay? That's a legal personality in their constitution. Okay, but now you come over to Article 3, right? Moors love to talk about Article 3. So there's Article 2. Now you come down here to Article 3. Okay, Moors love to talk about Article 3. Okay, and now Article 3, Section 2, right? Section 2, Moors love to talk about Section 2. Article 3, Section 2 talks about what? It talks about citizens, right? Citizens, right? Citizens or subjects. So in the Constitution of 1789 and the Constitution of 1871, right? Article 3, Section 2, right? Talks about citizens or subjects. Right? Okay, wait a minute. Let's go back over to Georgie's letter. George Washington's talking about who? Citizens and subjects. You see that? Mm-hmm. Now wait a minute. If we go back to their Constitution, if in fact Article 3, Section 2, right? Section 2, Clause 1 talks about citizens or subjects. But wait a minute. We already know who the citizens are. Isn't that common sense? We know that's who? Americans.
Yeah.
But who are the subjects? Why don't you ever hear the United States of America and their so-called constitutional scholars writing books and talking out loud about who is this identity of subjects? Because we already identified Indians, but we know who the Indians are, right? Most people know what Indians are. If you held up a picture, you say, oh, yeah, those are Indians. We know who citizens are, right? Citizens. No, those, you hold up a picture, oh, you're Americans. Okay, if I hold up and I say, point out the subjects. You say, huh? Well, what do you mean subjects? Who are the subjects? Yeah, that's a good question. Why don't the United States of America talk about this word subjects in their Constitution? See, they don't want to point it out. But neither does the Moorish American teachers. They don't point it out. So it's three identities in their Constitution. Indians, Americans, and subjects. But who are the subjects? Okay, ask George Washington. He'll tell you. George Washington will tell you about these citizens and these subjects, right? Because let's read the definition again. Let's read that again.
The late emperor, very soon after the establishment of our infant nation, manifested his royal regard and amity to us by many friendly and generous acts, and particularly by the protection of our citizens in their commerce with his subjects.
Pause. All right. So the subjects and the citizens, all right, are all where? They're all where? In Morocco. So the subjects are who? Moroccans. Because we already know who the Americans are. So when the Moors was talking about Article 3, Section 2, talking about the judicial powers, Moorish Americans teachers didn't know what the heck they were talking about, because they should have told the Moors they're the subjects. And if in fact the Moors are the subjects, then guess what? The Moors have to now come back and understand that on the Treaty of Peace and Friendship, 1836 and 1787, you go down to Article 6, right? Article 6. What does Article 6 say? Let's read it.
Article 6, if any more shall bring citizens of the United States or their effects to His Majesty, the citizen shall immediately be set at liberty, and the effect restored. And in like manner, if any more, not a subject to these dominions, shall make prize of any of the citizens of America or their effects, and bring them into any of the ports of His Majesty, they shall be immediately released, and they will then be considered as under His Majesty's protection.
So the subjects under whose protection? His Majesty. His Majesty is who? Moroccan. So the subjects are who? Moroccans. Right? This is a treaty of peace and friendship. Moors are who? Moroccans. Moroccans under protection of a Moroccan sultan. This is treaty of peace and friendship. Okay, talking about the word what? Subjects. Right? Subject, there's that word again, Treaty of Peace and Friendship of 1786, 1787. Now you go over to the Treaty of Madrid, 1880, and it's talking about what? Now you come down to what? Article 15. You come down to Article 15, and what does it say? All right. Article 15, let's go through it again. Let's be redundant.
Any subject of Morocco who has been naturalized in a foreign country and who shall return to Morocco shall, after having remained for a length of time equal to that which shall have been regularly necessary for him to obtain such naturalization, choose between entire submission to the laws of the empire and the obligation to quit Morocco, unless it shall be proved that his naturalization in a foreign country was obtained with the consent of the government of Morocco.
So in 1880, they talking about this word subject again. There's the word subject again that Georgia was talking about in 1791. Now we fast forward to 1880, they still talking about subjects. Keep in mind, in the Constitution of the United States, Article 3, right? Section 2, Clause 1 talked about what? Citizens or subjects. So who are the subjects? They're what? The citizens are, the subjects are who? Moroccans. They're subjects of Morocco. They're not subjects of America. They're subjects of Morocco who have what? Who have been naturalized, in a foreign country. What's the foreign country? United States of America, because we're talking jurisdiction.
Yes.
You're in their jurisdiction because you got what? Naturalized under their laws. Dred Scott became naturalized under their laws, but before he was naturalized, he was just simply what? He was just a subject of Morocco. He was Moroccan. He was a subject. Subject. So therefore, these subjects that George Washington was talking about in 1791 don't return back to a Moroccan government, then this happens in paragraph 2. Let's read it.
Foreign naturalization heretofore acquired by subjects of Morocco, according to the rules established by the laws of each country, shall be continued to them as regards all its effects without any restriction.
So therefore, these subjects that George Washington was talking about, and these subjects that the Sultan is talking about, are all Moorish subjects. They're all Moroccans. And they've all been naturalized. And since they've been naturalized, if they don't return back to Morocco and pledge their allegiance back to a Moroccan state government, then they remain in the jurisdiction of the United States of America under paragraph 2, foreign naturalization. So therefore, foreign naturalization means what? You was a foreigner, now you became an American, you got adopted. Because it's foreign naturalization. A foreigner adopted you. The United States of America is a foreigner in Morocco, and that foreigner adopted you as a stateless person. So foreign naturalization heretofore acquired by subjects of Morocco, according to the rules established by the laws of each country, shall be continued to them as regards all its effects without any restrictions. So the United States of America came up with laws such as the 13th Amendment, 14th Amendment, 15th Amendment, Naturalization Act of 1870, and then the Madrid Convention comes out 10 years later of 1880, and then it clarified the Naturalization Act that the United States did to the what? Subjects. So now you go back to their Constitution, and now all of a sudden the Moors are no longer subjects. Now they became what? citizens under the 13th, 14th, 15th Amendment, the Naturalization Act, and then it got solidified by a treaty commonly known as the Madrid Convention of 1880. Article 15, paragraph 2. You see, but Moors are all subjects. And you're a subject until you finally return to a Moroccan state government. Listen to me. I got to talk about this, Moors. Look what the Moorish Americans are doing right now. This is Black's Law Dictionary. What I'm about to say, I say with respect. Let me just say that first. I want to talk about good brother Jamal Bey of Rising Moors. I want to talk about good brother Lamont Hill, right, of enforce the Constitution. Both Lamont Hill and Jamal Bey got caught up doing what? Having arms in their possession. They had arms in their possession. And right now, what is their legal defense? What's their legal argument? First things first, are they using Moorish American state laws as their defense? That's the question. Well, the answer is what? No. Are they using Moroccan state laws as their defense? Well, the answer is no, because no Moroccan state recognizes Jamal Bey or Lamont Hill because they haven't returned to Morocco to pledge their allegiance to a Moroccan state. So the answer is no, they're not using Moroccan laws as their defense. So what are they using as their legal defense? They're using what? American statutes. They're using American case law. Because they're both Lamont Hill and Jamal Bey. I say this respectfully because it's AMPAC study session, educational platform. I'm trying to speak publicly because Jamal Bey and Lamont Hill represents the greater part of all the Moors who have the same mentality when it comes to arms. But I'm going to school the Moors today. Now I got much love for Lamont Hill and Jamal Bey, but I got to talk about this out loud so we all learn from this. We've all been taught to use the Black's Law Dictionary, so Lamont Hill and Jamal Bey is using the Black's Law Dictionary as a part of their defense. It's just terms, right? But the Black's Law Dictionary was used and it was invented by who? Henry Campbell Black, right? But Henry Campbell Black is American writing these laws, okay, these terms, right? So as soon as you open up the Black's Law Dictionary, definition of the terms and phrases American and English jurisprudence, ancient and modern. So it's American laws, and it's some ancient stuff they're talking about, right? But wait a minute. Okay. If I go down to page 3. We're still in the opening. Okay, this is the preface, okay? Gotta start from the top.
The sustained and growing popularity of Black's Law Dictionary since its appearance more than 75 years ago is a striking tribute to the scholarship and learning of Henry Campbell Black and to the essential soundness of the plan adopted by him for the compilation of legal lexicon. In accordance with the original plan of this work, consistently adhering to in all subsequent editions, the law student confronted in his casebooks with reports from the yearbooks or with extracts from Glanville, Bracton, Littleton, or Coke will find in this dictionary an unusual complete collection of definitions of terms used in Old English, European, and feudal law. The student will also find in this volume on page 1795 a useful table of British regnal years listing the sovereign of England for more than 900 years together with the date of accession to the throne and the length of reign.
Okay, so what is Black's Law Dictionary telling you? They're really getting their definitions from what? British regal years. They're getting their definition from the British Parliament. Right? So Black's Law Dictionary is really based in British law. That's why they call the Bar Association attorneys have to pass the Bar Association, right? The British Accredited Registry. Right? So good brother Lamont Eel and good brother Jamal, they'll be using Black's Law Dictionary for their defense because they're looking up case law, right? Depending on the subject matter of what they've been detained for, which is holding arms. All right? Now keep in mind, good brother Jamal Bey and Lamont Eel are invoking what? The Constitution of the United States. And they're trying to say under the Second Amendment, they got rights to bear arms, in which they don't even realize out loud. They're saying what? They come under the protections of the laws of America. Well, where in America get its laws from? It got it from Great Britain. That's what they're saying in the Black's Law Dictionary. Okay, so let's go down to this page 795 that talks about this British regal, right? Okay, the British regal years. Okay, more. So on this page is the table of British regnal years. Okay, so on this page, this is Black's Law Dictionary. It's going to tell you now the history of Great Britain. Okay, so it's about the history of Great Britain's lords, right? Now, I'm not going to go through all these years, especially since my computer's acting up a little bit. But what you got to understand is the Black's Law Dictionary is based in British definitions and talking about parliamentary procedures. So good brother Jamal and good brother Lamont, they're going to be trying to enforce American laws, and American laws came from British parliamentary laws, right? So if Lamont Eel and Jamal Bey are trying to enforce British laws and American laws, that means they're not enforcing what? Moroccan laws. They're using American statutes and American case law for their defense, which automatically makes them still what? Subjects of Morocco. That means they're still what? They acquiesced, right, and consented to come under the protections of a foreign country because they're using that foreign country's laws for their legal defense. So recently, good brother Jamal Bey got his case dismissed. Now wait a minute, that's not a verdict. That's not a ruling. The case just got dismissed. So I'm happy for the good brother because he gets to stay home with a lovely wife, lovely daughter. That's good for him to be a good family man and stay home. That's why all the more would rather see good brother Jamal, who's a warrior. He now can let go of that stress of fighting that case because the case got dismissed. But let's get an understanding here. Why is the case got dismissed? Well, of course, we're looking at what? Procedural default. For whatever reason, the United States of America and the several union states is looking at Jamal saying Jamal is one of the last hardcore Moorish Americans to be out there marching with that Moorish American regime. Jamal's going to push that old paradigm about being Moorish Americans. The United States of America is using what's called political posturing to make sure that case gets dismissed. That way Jamal is out here as a free man, still talking about what? Moorish American principles. Because if good brother Lamont Eel goes to jail, then who's going to be left to be out here banging the drum for Moorish Americans? Ain't gonna be nobody left. If Jamal would have went to jail and Lamont went to jail, who's gonna be out here as the leader for the Moorish Americans? Keep talking about enforce the Constitution and being a Moorish American. So they had to let one of them stay out of jail so they keep banging that drum. This is political posturing. Listen to me, Moors. And this is not about Jamal personally, because I love the good brother. I'm glad he's home with his family. That's where I want him to be. That's what we all love for him to be. But let's talk about the politics of the United States. We're talking politics. What's their tactical execution? Why did they dismiss the case? It's because Jamal is a political pawn to them. I'm telling you these truths. This is my 2 cents. This is my assumption, but it's based in the merits that they had Jamal on camera with all these weapons. He had on Kevlar. He had on battle dress fatigues. And he didn't have a permit for any of those weapons. So, and he held up what? The street for like, what, 9 hours? They took a tactical defensive position against the police. They got him on all kind of counts. Also, they dismiss it. Think about it. Why did they dismiss it? They need Jamal to be out there talking about being a Moorish American. Don't let the United States of America and the several Union states fool you. They got together to make sure that case went away. That way Jamal remains free, so Jamal keep banging that drum. Well, why did they let him stay free? And that's not to take anything away from Jamal, because he worked hard on that case. I'm sure he stayed up day and night because he wants to stay home with his wife and his daughter. And I'm glad he's home, but let's talk politics. You see, you got to understand something, Moors. Moroccan statehood, Moors are talking about it from the East Coast to the West Coast right now. It's a topic that the FBI is keeping a finger on because they know the Moors are starting to declare their independence and they're restoring constitutions in each of the territories. Don't let the United States and the FBI and the several Union states fool you. They know all about AMPAC study session. So they need good brother Jamal Bey to be out here talking about Moorish Americans in order to distract the new conversation. Because Jamal Bey is the only Moor that's got any credibility of being a warrior because they got Lamont locked up. Lamont ain't out here going hard in the paint. Only Jamal can do it now. So the United States is pushing all their chips to the middle, thinking that Jamal going to be out here and be a die-hard Moorish American in order to now muddy the waters to try to control the narrative of being a Moorish American. So Jamal says, hey man, I won. I got the case dismissed. And I'm going to sell this transcript for $50. And all the Moors are going to jump on that bandwagon trying to get all their cases dismissed regarding holding on to firearms as Moorish subjects. Because they're Moorish subjects. I just showed you a little bit of history on it. So what the Moors got to understand is, it's incumbent upon good brother Jamal Bey to understand the game that's being played on him. They're using you, good brother Jamal Bey. They're using you as a political pawn to try to keep Moors distracted as you being the piper for the Moorish Americans. But if you would ask me, I think Jamal Bey going to start studying international law and find out about statehood, and he's going to start working with Moroccan states so that he can declare his independence, restore a constitution, and return back to Morocco, because now he's renounced and denounced the jurisdiction of the United States of America. But this is all going to be on Jamal, isn't it? It's all going to be on Lamont. They got to study. Now that Jamal don't have that pressure on him no more, listen to me. He don't have the pressure of that case no more. Jamal don't have no excuse not to start studying and learning about Moroccan statehood. But the United States has put all their bets on him not to want to understand Moroccan statehood. You got to understand what I'm saying. They think he's going to be a political distraction to give the United States more time. Because the United States always looking for time. They like to stall, deny, and defend. They're going to use Jamal to do it. And I'm saying this, with respect to Jamal. Jamal, you got to come back home and prove to the United States and the several Union states that you're not going to go for the banana in the tailpipe, that you are actually going to learn what the treaties say you have to do, brother. Don't go back out here beating that drum about being a Moorish American. You got to course correct. Now, let me prove something else to the Moors. Not only does the United States of America enforcing American and British laws, which is not Moroccan laws, it's British American law. We're talking jurisdiction. What else? As I start to close out. This is the Act out of Sheriffs of 1906. I need to show the Moors something regarding arms, because Moors keep having arms in their possession. Let me show the Moors something that your Moorish American teachers are not going to teach you or show you. We're going to go to Article 26 of the Act out of Sheriffs, okay? We're going to go to Article 26, okay? Control F. What I want to show the Moors is something that we should all be aware of. All of us should be aware of. And that is Article 26, right? Okay. Let's go Article 26. Okay. We're going to read Article 26, Moors. All right. Of the Act out of Sheriffs of 1906. Okay. Nova.
Article 26, the Mogazin may retain the confiscated merchandise either for its own use, if able to utilize it, on condition that the subject of the empire shall not be able to get possession of it, or it shall dispose of it abroad. The conveyances of the same on shore may be confiscated and shall be sold for the profit of the Sharifian treasury.
27.
27. The sale of arms condemned by the Moorish government shall be prohibited throughout the Sharifian empire.
Okay, so what is my point here? Now we're talking about arms. Keep that in mind, Moors. Arms, okay? Talking about arms. So if the Moorish government confiscates arms, guess who we're disallowed from giving arms to? We cannot give arms. Listen, Moors, this is part of the treaty. Article 26, the Act of Algeciras. Article 26, the Majin, that's the Moorish government, may retain the confiscated merchandise, arms, either for its own use, if applicable, to utilize it, on condition that the subjects of the empire shall not be able to get possession of it. You see that? The subjects of the empire, right? Who are the subjects? More subjects who are still under the jurisdiction of the United States of America. The subjects of the empire shall not be able to get possession of it. Of what? Arms. So what this treaty is saying, right, in Article what? 26, the Majin, the Moorish government, may retain the confiscated merchandise, that says arms, either for its own use, if able to utilize it, on condition that the subjects of the empire shall not be able to get possession of it, or it shall be dispensed of it abroad. So more subjects are not allowed to have arms. Listen, Article 27. The sale of arms condemned by the Moorish government shall be prohibited throughout the Sharifian empire. So we're talking arms. So the Moorish government is in charge of arms. Okay? But guess what? The United States of America has been enforcing the Act of Algeciras against who? Moorish subjects. So Moorish subjects are not allowed to have what? Arms. They're prohibited. You see that? Subjects of the empire shall not be able to get possession of it. So the empire is not supposed to have arms. So when you see good brother Jamal Bey and Lamont Hill, and they got these arms, and they say they're Moors, what type of Moors? Moorish subjects, because they're still under the jurisdiction of the United States of America. The United States of America say, oh, these Moors, who are still subjects, are not allowed to have what? Arms. Subjects of the empire should not be able to get possession of it. Of what? Merchandise, such as what? These arms. You see, the United States got caught up in a catch-22. What do I mean? Their Constitution recognizes who? Indians, Americans, and Moroccans, and the Moroccans are listed as subjects. Dred Scott was a subject. Now that they made Dred Scott a citizen under the 13th, 14th, and 15th Amendment, and now that they made Dred Scott a citizen of the United States, guess what Dred Scott has a right to do? Bear arms. Now Dred Scott got a right to invoke the Second Amendment, to have arms. But the treaties say more subjects are not allowed to have arms. So the United States has been running around the whole time trying to figure out how to keep more subjects from having arms, while simultaneously they made the more subjects citizens. Therefore, the more subjects had access to arms legally under the Constitution as second-class citizens. So now the United States is trying to figure out how to keep these Moorish Americans from having arms, because Moorish Americans are Moorish subjects who ain't supposed to have arms. So they don't know what to do with the Moorish Americans, because they don't want to tell the Moorish Americans their rights in order how to bear arms. And how is the Moors can bear arms? How can they do that? Well, the Moors have to return to Morocco, don't they? They got to bring those arms back to Morocco. The Moroccan state has to register those arms with the Moroccan state. That way those Moors who are carrying arms are Moroccan nationals and not Moor subjects. The Moroccan nationals that are bearing those arms lawfully because they're recognized by the state to bear said arms. So we need good brother Jamal Bey and Lamont Ill to return to Morocco and choose between the entire submission to the laws of the empire and pledge their consent back to a Moroccan state government. Or you can remain as a Moorish American claiming you're enforcing the Constitution and the Second Amendment to bear arms, and they're going to end up doing what? Locking you up again. That must be understood. I end with that. Islam.